Good morning, everybody. Welcome to this Medical Legal Aspects Symposium, National Symposium. I hereby convene this meeting. I request Professor Indermohan Rustagi to proceed further.
स्पीकर ही बुलाया सर.
आप इनवाइट कर दो स्पीकर फर्स्ट स्पीकर इन ओके आई विल डू इट मैं बोल दूंगा. So to move ahead, Dr. Deshpande, due to an emergency, had to leave Mumbai. So his talk on New Consumer Protection Act 19, difference from old act and its effect, shall be presented by Dr. Prakash Marathe. I request Dr. Marathe to begin the session.
Welcome all of you for this medical legal symposium, and all important aspects are covered in this particular symposium. Our chairman, Dr. A. Deshpande, has prepared this presentation, but he had to leave yesterday because of the emergency situation. So on his behalf, I am presenting this topic, that is New Consumer Protection Act 2019, difference from old act and its effects. So he is the medical legal consultant and chairman of legal committee of AIOS and Maharashtra Ophthalmological Society also. The Consumer Protection Act, it is applicable. Hello? It's just one slide before. Yeah. Applicable from 20th July 2020. So service means service of any description which is made available to potential users and includes but not limited to the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical and other energy, telecom, boarding or lodging, or both housing construction, entertainment, amusement, or the purveying of news or other information, but does not include the rendering of any service free of charge or under a contract of personal services. So old jurisdiction versus new jurisdiction. Like in district commission, it was the coverage up to 20 lakh was awarded. And now it is up to 1 crore. That is the worst thing. The limit depends on bill paid. This is good thing from our point of view. But no limit of demand even more than 1 crore. State commission, in the past it was from 20 lakhs to 1 crore, and now it is from 1 to 10 crore. National commission, in the past it was above 1 crore, and now it is more than 10 crore. So this is the worst thing in New Consumer Protection Act. The effect is, as per new act, the limit is dependent on amounts paid by the consumer, and that limit is 1 crore. So luckily one thing is that most of our bills are less than 50 lakhs. So that is the good thing. But then the compensation has been increased. So all cases in which patient has paid the bill less than 1 crore will be lodged in district commission. That is the thing. That is practically all cases will go to district commission. Jurisdiction for lodging the case. In the past, in the area of cause of action, that is district, state or national consumer redressal commissions area as per their limits. So suppose you are practicing in Delhi, probably that particular area. Now you are in Delhi and patient is from Chennai, patient can lodge the complaint in Chennai. So new, at the cause of action or at the place of residence or workplace of the consumer, that is patient. And again, the worst thing is it can be online, so easily accessible for the patient. The effect will be the patient can lodge a case at his residence or place of work. So a patient of Chennai taken treatment at Delhi can lodge a case in Chennai, and doctor has to run from Delhi to Chennai all the time for all the hearings. He can lodge the case online also, and then doctor can answer online. So easy accessibility for patient. Old provision, there was deposition of 25,000 was required, and limitation period for appeal was 30 days. New provision, deposition of 50% ordered amount, that is the change, and limitation period of appeal is 45 days. Appointment of judges, there is some difference. Old provision, the judges and staff was appointed by judiciary. New provision, that is clause 29, the judges and staff will be appointed by central government. The qualifications and other details will be decided by central government. So what is the effect? The doctor may require to deposit a big amount if the district commission has ordered a heavy compensation. Suppose there is crores of compensation asked for by the patient, and unfortunately it goes against the doctor, and he is going for the higher court. Still you have to deposit that amount. That is the worst thing. And suppose the result is after many more years, there is no interest given to that doctor. But you have to make provision of depositing that money into the court. So appointment of judges, the genuine judiciary judges may not be appointed, and then the decisions may be affected. New clauses, that is, if the complainant is not heard in 21 days, then it will be taken as admitted. This is again the new addition. After first hearing, the complainant will be referred to mediator. That is a new provision. So there will be dalals, the people in between. They will approach doctors and hospitals and ask them, okay, we'll settle the matter, give us the money. So consumer mediation cell is a new thing which is added and which is the routine according to the court of law. All the cases will be admitted and will be sent to mediation. So that choice of mediation will be given to each and every case. Again, few of the new clauses. Any terms of contract which are unfair to consumer can be made null and void by state or national commission. Product liability action may be brought by complainant for defensive product, that is service. The effect will be any terms of contract which are unfair to consumer can be made null and void by state or national commission, which may be dangerous for the doctor or hospital. That's the thing. Then up till now, negligence was the only one cause for ordering the damages. Negligence, that was the only thing which was under consideration. Now what has happened? The services of any doctor or hospital may be labeled as defective and substandard, and damages may be ordered. So it is not only negligence, but few things are added, and that's the new provision. So the Central Consumer Protection Authority, to be known as the central authority to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements which are prejudicial to the interests of public and consumers, and to promote, protect, and enforce the rights of consumers. Next, clause 15, that is investigating authority. The central authority shall have an investigation wing headed by a director general for the purpose of conducting inquiry or investigation under this act as may be directed by the central authority. So effect will be Central Consumer Protection Authority, RAJ, will start by inspecting any hospital suo motu, worst thing to happen, and lodging cases against them. So Inspector Raj, and I think with all these things, what I have tried here, that is a new things which are added in this new Consumer Protection Act 2019, getting worse and worse for medical fraternity, and hope all of us shouldn't be in that particular trap. One important thing which was the rumor probably, because of CPA 2019, people felt that medical fraternity and doctors are not under CPA. But that was a rumor. Because in the list of exclusion, which is given by the parliament, in the list of exclusion, medical fraternity and doctors are not written. So unless it is written in the exclusion list, doctors and hospitals are not under the purview of CPA. Like you are still under the purview of CPA. Remember this. For that, the pains should be taken by higher authorities like AIOS and IMA, and ask the government to exclude medical fraternity and doctors from that list. Then and then only medical profession will be out of CPA 2019. Thank you. Thank you so much.
I now call upon Dr. Inder Mohan Rustagi to speak on the topic documentation, how important it is in the CPA court.
Good morning. Documentation, how important in medical legal cases? Just now, Dr. has said that things have changed, so society has changed these days. And so keeping in pace of the society, have we also changed or just forget our old teaching? Mistrust in the society for doctors is increasing, as well as there is some kind of the degrading moral values of the few doctors and intolerance. And the about most important thing is yellow journalism, that is aggregation of the news events, scandal mongerings, or these kind of dalals in between. Healthcare division in the multinational companies, lack of communication, poor record keeping, and problems with the medical fraternities. Mobocracy is the new thing. Uh, Something happens, mob creates the vandalism, and it is in the news. Yellow journalism comes. So a doctor is at the stake, and recent cases of gynecologist in Rajasthan. So we have to change the attitude of the society. The call as money mongers or the predators, and we are healers and will remain the same. But the most important thing for assault or for medical legal cases is poor record keeping. Things have changed a lot. Doctors has to change. Family doctor concept is changing. So we also have to change. It is not the things as is used to be in the past to keep the hand on the shoulder and things are done. So we have to be precise and we have to have a proper record keeping. So medical record keeping is a science in itself. And the importance of the medical record keeping is it reflects and creates excellence in the medical care. It is a standard of care. It is a legal protection for the patient as well as physician in the dispute. Failure to document important details leads to adverse patient outcomes and malpractice suits. Another thing is ethical issue. It assures patient confidentiality and ensures that the standard of care are met. Poor records means poor defense, but no records means no defense. You're caught. So purpose of the proper patient medical records is patient care. It provides the documented basis for the planning patient care and treatment, and as well as a way of communication. Things TPA has come in between. So billing and reimbursement are the big way. Improper record keeping can result in the declining claims to the patient as well as to the hospital. Another thing is research and quality management. Legal documentation relies on documentary evidence in a situation if the medical negligence is alleged. So we have to have a proper documentation. Medical documentation consists of electronic health records. EMR is the thing in the work. Physical examination of the patient. Consent forms, properly signed consent forms, especially in local languages. That is again in the system, and even our AIOS has come out with the local language consent forms. We have to have a full operative notes with proper timings. If you don't put timings and the case becomes medical legal, we are in trouble. Progress notes, nurses notes. So these things starts with itself. So safety starts with ours itself. Then comes physician or surgeon's notes, physician certification, physical therapy, physiotherapy notes, records with the batch number of the drugs which are specially used in eye, intraocular drugs, injections, viscose. Proper investigation, they have to be signed by the proper pathologist or microbiologist. proper discharge with instructions like if you are not given instruction to the patient, the pain, watering and redness has to be reported back. That again things becomes a medical legal issue. So discrepancy summary given to the patient and in the hospital record, that should not be there. It causes a suspicion. Tampering with the medical records. And if tampering with the medical records is there, doctor is again caught in the, or doctor institute again caught in the civil court cases. Undated prescription land in doctor in trouble if the patient misuses it. So referral notes again are important part of the patient records. Always keep a duplicate copy of the referral notes with the patient signature that the patient was well informed or attendant were well informed in time whether they are not willing to take him to the another hospital or center and something untoward happens to the patient. Again, doctor is held responsible, but patient doesn't go at his will. So doctor is at a safe point in medical legal cases. He is legally bound to maintain the confidentiality of the personal medical record. Illegible handwriting again becomes a case in medical legal cases. Lack of documentation, omitted medications, treatment, they all come under poor documentation. These days things are gadgets have come. So videotapes of the endoscopic procedure, phaco procedure, MICS procedures, electronic fetal health monitor chart, continuous ECGs or pulse oximeter, they become all important documents in the court of law. And another thing is those records which are indirectly related to the patient management, that is accounts, service records, administrative records of the staff itself, they sometimes become the evidences for litigation purpose. And it is a concentrated effort of a number of people which are involved in healthcare. But the center or onus lies on the doctor. Doctor is at the pivotal role. He is all responsible for his staff doings. Characteristics of the good medical record is it has to be accurate, it has to be accessible, it has to be comprehensive, it has to be consistent, and it has to be timely recorded. The issue of medical record keeping guidelines are that you have to maintain indoor records in standard pro forma for 3 years from the commencement of the treatment. Request for medical records by the patient or authorized attendant in some kind of referral or something, that has to be acknowledged and documented, has to be issued within 72 hours. We have to maintain a register of certificates with the full detail of the medical certificates issued with at least one identification mark of the patient and his signature, and effort should be made to computerize medical records for quick retrieval. It is advisable to maintain records for 2 years for outpatient. It is advisable for 2 years and 3 years for at least inpatient patient and surgical cases. In pediatric cases, up to the age of the majority, if the cases file against medical negligence, we have to have that record. And in death cases, permanent record keeping has to be there. Subject of medical legal cases has to be maintained until the final disposal of the cases, even though either a complaint or notice has been received. So by and large, medical records are the property of the hospital, and it is the responsibility of the hospital to maintain it properly. Records should be in a safe custody. Unsigned record has no value. Failure to provide medical records to patient on proper demand always amounts to deficiency in service and negligence. Medical records summon the court of law. They are used in criminal cases, RTA cases, labor court cases, insurance claims, medical negligence claims. And, sometimes becomes a criminal cases also. So there are the places where the medical records are of utmost importance. Policy for disposal of the cases are, once the time period is over as prescribed, by shredding or pulping according to the provision of the state laws, and details of the document destroyed by the hospital or the company has to be recorded in the register for proper disposable by employees who are disposing the records under proper orders for destructions. So proper documentation for patient record and in claims is important. That is to protect the doctor, to protect the institute, and to protect your patients. Obviously, you are the provider, so it is to be you are the at the center. Complete and accurate medical record keeping always help that your patient get the right care at the right time. So remember, be precise, up to date, and descriptive in records, come what may. Thank you.
At the end, we are having panel discussion. That time we will be taking your questions. Thank you.
And that way some questions may be answered in the next talk. So we'll keep it, but please stay late.
I now call upon Dr. Nirmal Frederick to speak on the topic addressing medico-legal problems of CPA 19 with accreditation standards.
Good morning, friends. Thank the chairperson and AIOC for this wonderful opportunity. And so my topic is on the preventive measures. The previous speakers have made my job easier. So this is my disclaimer. I'm with the honorary capacity with NABH. And I'll be talking to you about how we can address medical legal challenges, both prevention as well as safeguarding our interests and our hospital interests with the accreditation standards. As you all know, medical errors do happen, and many times it's accidents, and sometimes it is incident. And we have to know why this happens from the right perspective. The relationship of medical errors to negligence, and why do people sue their doctors, and what could be the potential solutions to the problem of medical errors. So there are so many other professional services as well as industries, but this question often comes to our mind: why is medicine so susceptible? Since we are in medicine, so the basic thing is lack of awareness to the problem, not only from our point of view, also from the general society point of view. There is a blame culture of silence. So many times the good people maintain a silence, and this culture of silence makes the other to blame and shame mentality. And there are system constraints. Ours is a underdeveloped system, infrastructure issues, staffing problems. There is a huge fatigue, particularly post-COVID, and knowledge requirements that is not addressed properly in the medical curriculum. Communication and continuity of care is not addressed. And human error is one concept that is extensively studied in other industries, but unfortunately not well studied or analyzed in medical field. So this occurs due to incomplete knowledge and the tendency to apply rules to simplify problem solving. This is what exactly happening in our country, where they want to regulate us too much without understanding the basic issues. So errors in healthcare must be accepted as an accident. This is what the concept as a society we have to promote to the other industries. We have to do the root cause analysis and see what is the root cause analysis and see how we can address the system flaws and not shame and blame the profession. So unless we do this, find the root cause or offer solution or institute preventive measures, this litigation is going to increase in our country. All errors are not negligent. I think this we have to enforce not only among our professionals, but also to the other industries. And not out of so millions of hospitalization, there are only 1 to 2% of negligent injuries. And how many sue the care providers? Hardly 13% of the negligent injuries results in a claim process. So even though the numbers are limited, but it has huge implications on our practice pattern. And reason why people sue the doctors, basically the passing comments by another doctor. So one of the doctors is responsible for another doctor's issue, and there are now the legal profession is also needing money out of our accidents. So why patient complains? When they see that the standards or tenets are not followed in the day-to-day practice or perceive that they are not followed. So very often it is instigated by another medical professional or care provider. and they know that standards are everywhere. They compare the standard with other industries. And happy patient don't sue their doctors. So we know that. So what are the basic tenets of healthcare and accreditation standards? Safety, avoiding injuries to patients, no harm. That should be our motto. Effective evidence-based medicine, patient-centered, respect their dignity, rights, and responsibility to the individual needs and values, and it has to be timely. Most of the complaint happen because we have not provided timely care. So we need to reduce delays for the receiver and provider, and it has to be efficient and equitable. So these are the unique challenges in our specialty. Basically, outreach services. We reach out through the surgical camps. Cluster infections happens, and this is widely reported in the press and media. Daycare surgery and follow-up issues. So previously we used to admit for 3 days or 5 days. The patient is under care, and it's also possible to take care of the accidents or poor outcomes. But with daycare surgery, this is becoming an issue. And variety of service patterns, paid services, free services, and charity unit. They tend to compare paid services with the free or charity services. And of course, insurance, as Dr. Inder Mohan said, it's compounding the problem with reference to documentation and follow-up issues. And the technology and advancement, premium services come with premium cost. Quality has its own cost. So unfortunately, patients don't understand. And we also spoiled ourselves by giving over-promise and under-delivering the outcomes. So why we are ignorant as a professional? We are not this has not been part of our medical curriculum. We are not taught about medical legal challenges. Nobody wants to talk about it openly, even if they receive a notice. Feel it may not happen to us. This is the major problem. So we'll deal with it when it happens, and at that time it is too late. So there are two issues with reference to medical negligence. One is the act of omission, and another one is act of commission. So act of omission is all these 6 important points. Not performing essential tests, not giving appropriate advice, counseling, or informed consent, not maintaining aseptic precaution in the OT, not asking about the drug sensitivity and systemic disease, ruling out ocular pathology, and not seeing that the patient is furnished with proper records. So wrong side, particularly ophthalmology hits the incidence of wrong side errors, which is absolutely preventable. And these are the root causes: the miscommunication in the OT, incomplete patient assessment, verification policy not followed, and these are the common complaints. And majority of these causes of wrong side and side surgeries are preventable. So how we can do that? Providing standard of care. So we need to take steps to prevent these incidents and accidents. So basically 4 important topics: failure to comply with legal and professional responsibilities, problems related to medication errors, the administrative errors, as Inder said, it's a tariff and billing related issues, and of course inadequate consent and medical records, which the next speaker will be covering. So failure to comply with legal and professional responsibility, we need to have certain system, and we have to minimize the government regulation and also the rates for which we have to comply with that. And this is becoming a big problem for small-time practitioners, and the compliance is becoming difficult because of the red tapeism and corruption in the system. So with accreditation standard, this is followable. This is the standard related to the licenses, where there is a mechanism to regularly update licenses, registration and certifications, and this becomes a responsibility of top management. The third issue is the biomedical wastage. So this is another critical area where Pollution Control Board has been given huge powers to seal and inspect the premises at their will. So we have to comply with those regulatory requirements. And the fourth one is the Safe Medication, Drug and Cosmetic Act. If you are having a pharmacy, we have to follow all the norms given by the NDPS Act as well as the DCA or Drug and Cosmetic Act. The fifth one related to the manpower. So this is where most of the hospitals get caught, particularly the mid-level and large institutions. All the statutory compliance is mandatory. Most of the problem comes with our own staff with reference to ESI or PF or professional tax and gratuity. So we have to follow them diligently. And sixth one given by our the newly named NMC, Professional Conduct, Etiquette and Ethics. So that's binding on us now legally. So there are multiple complaints, not only in the CPF forum, but also with the medical councils. In many states, it's increasing. So we have to be very careful about our ethical requirements. Then seventh one is the right of the patient, the consent. The next speaker will be talking to us about this. I will not go into the details. The second major issue is reference to patient safety and medication errors. So safety ensured with accreditation. There is always a plan for fire and non-fire emergencies in the accredited facilities, so that if there is an accident, this really helps not only during the emergency but also safety reference to the fire. And litigation related to emergency is reduced in accredited institutions. So because the systems are in place, so we have to have safe infrastructure, standard focus on patient safety related equipment, CCTV camera, the water tanks are cleaned appropriately, biomedical wastage regulations are followed, and there is a crash cart which is available and accessible in case there is an emergency. The last two are administrative related, tariff related. So there has to be a standard billing and transparent tariff, and this is not also mandated by the standard but also the insurance company. The fourth one is failure of communication, inadequate consent and medical records. So patient flow have to be seamless in the hospital, and this is the common cause of dissatisfaction. We have to focus on the time taken for care delivery. So I'll be finishing in a couple of minutes. So common cause of litigation is this CCC failure, consent, communication, cost, and not effectively taking the complaints and feedback. So we have to have a system established for this, and we have to master this CCC also, apart from our cataract related CCC. Consent, counseling and communication is very important, particularly if you are breaking bad news, you have to be master of this counseling and communications. These are some mistakes we cannot defend, so we have to have a focus and system like surgical safety checklist to prevent these errors. And these are statutory documentation. We have to maintain them as per the requirement for 6 years for inpatients and at least 3 years for the outpatient records. And these are the mandatory standards for maintenance of medical records. So how does accreditation help in reducing medical legal challenges? Good infrastructure is directly proportional to safe care. Process control, so documentation and good communication skills. Licenses are in place, so this ensures safety in facing medical legal challenges. Good structure and good process gives good outcomes. So accreditation standards help in preventing medical legal challenges by having a good standard of care, and these standards help in reducing the risk and improving the quality. So problems are not stop signs, they are guidelines. Once we follow these guidelines diligently, we can prevent medical legal challenges. Thank you so much for your kind attention.
Thank you, Dr. Nirmal. Now I invite Dr. Manoj Chandra Mathur to speak on the role of insurance company in mediation by CPA appointed mediator, new CPA under new CPA Act 2019. So over to you, Dr. Manoj.
Yeah. Good morning. I thank AIOS and the convener Dr. Deshpande for this opportunity. I shall be speaking about the impact of new CPA Act 2019, role of insurance company in mediation. Basically an overall act, like as Dr. Prakash Marathe talked about the earlier act of 86, which was replaced by the new act in 2019. It had a three-tier redressal system at the district level, the state level, and at the national level. And in 1986, this act had given wide definition of a consumer as a person falling in this definition is only allowed to file the redressal application in this act of 1986, which was subsequently given a broader perspective. The term consumer was given a broader perspective in the in the latest act. So, Consumer Protection Act 2019, there was an initial euphoria among the medical fraternity that the term health is deleted from the purview of the CPA. But the Supreme Court refused to intervene with the judgment of the Bombay High Court and opined that in CPA 2019, medical services shall fall under the ambit of services as mentioned in section 242. This is clear. The role of AIOS and the other bodies come subsequently, like as Dr. Marathe said, this has already been opined by the Bombay High Court, and SC refused to interfere with the decision of the Bombay High Court. The task becomes much more Herculean. Any matter in medical negligence on the part of service provider will be considered as a deficiency under Section 42(11) of the new CPA. And Section 69(1) of the CPA 2019 lays down a time limit within which the complaint against medical negligence needs to be filed as 2 years from the date of injury. So it is mandatory for all of us to maintain our records for at least 2 years. And as suggested by Dr. Rostagi, the surgical records for at least 3 years. But if there is a malpractice case pending, it has to be till the disposal of the case. And if it results in the death of the patient, forever. So, the Consumer Protection Act 2019 seeks to revamp the Consumer Protection Act mechanism by repealing the Consumer Protection Act 1986. A striking feature of this act relates to the establishment of consumer mediation cells for settlement of consumer disputes through the settlement mechanism. While retailing the certain old provisions, the new act has certain new provisions that tightens the existing rules to further safeguard consumer rights and create exhaustive protection law. And the 3 provisions that impact medical practice from among the 8 prominent changes between 1986 and 2019 is the clause number 3 that adheres to strict norms for misleading advertisement. We have to be beware when we are trying to advertise even ethical advertisement. Changes in pecuniary jurisdiction, and the last but not the least, alternate dispute resolution, which I shall be highlighting about. What is a misleading advertisement? Like any misleading advertisement in relation to any product or service means an advertisement which they have, this is the legal terminology, let's not go into every word of it, but what is applicable to us is we need to give a correct perspective about the procedure, including outcome and risk involved, and to obtain proper comprehensive consent. And when we are trying to advertise our procedures or advertise our center or a hospital in the social media, we need to be very careful so as not to be caught on this clause. The next medical clause that is the medical fraternity is going to impact is, as already highlighted, the Consular Disputes Redressal Commission has increased the pecuniary benefits at the district, the state, and the national level. It was limited to 20 lakhs at the district level, which is now 1 crore, and for the state commission from 1 crore to 10 crores, and at the national level to over 10 crores. So how does this impact the medical profession? We need to take proper enhanced indemnity cover so to account for this. And then the last one, the alternate dispute resolution through mediation, which I shall be highlighting about. The term mediation can be defined as a voluntary dispute resolution process where the third party, that is the mediator, facilitates negotiation between the disputed parties to negotiate for their rights and interests by themselves. Mediation is a voluntary binding process in which an impartial and neutral mediator facilitates disputing parties in reaching the settlement. A mediator does not impose a solution but creates a conducive environment in which disputing parties can resolve all their disputes. A consumer commission may refer a consumer dispute for mediation at the first hearing itself of the complaint, after its admission, or at a later stage if it appears to the consumer commission that there exist any elements of settlement which may be acceptable to the parties. All the consumer disputes can be referred to for mediation except matters relating to the proceedings in respect of medical negligence resulting from grievous injury or death of the patient. These have to be tried, these can't be mediated. The parties can opt out of mediation at any time, but no appeal lies after the settlement of dispute through the mediation once the court pronounces its judgment. So there is a mediator, there are 2 aggrieved parties. The mediator can negotiate, can discuss the case separately with the 2 parties, or if you require, bringing them together. And you have the option to exit this mediation process at any time you feel that the mediation is going to go against you. But once you accept the mediation and the mediator refers this settlement to the court and court pronounces the judgment, then you don't have a right to appeal in the higher court. That you have to keep it in mind. And the role of insurance company and its repercussion to medical profession, currently based on our level of practice and our risk profile, we take indemnity insurance on AOY and AOA basis. What is this AOI? AOY is any 1 year. For example, you take an insurance of 1 crore. AOA, that means any one accident you can take your insurance cover saying that it is 25%, 33%, 50%, or 100%. What does it mean? If your insurance say, I have an indemnity cover of 1 crore on 25% basis, that means any one accident, AOA, one claim settlement, you will be getting a highest limit of 25 lakhs only. So this you have to take it in mind. These are the intermediary things that you need to consider when you want to cover yourself properly for indemnity cover. Since the pecuniary benefit limits are raised, the patients or their advocates may be tempted to file for compensation. And now since insurance company represents the doctor, see, you have taken an insurance from an insurance company. The insurance company will be tempted to settle it out of court and finish off the matter, not taking into consideration your reputation. So that is why you need to be more careful. And since the insurance represents the doctor, it may accept mediation in frivolous cases also, and there is scope for malpractice in this mediation process. And to exhaust the indemnity of the health professional. So the health professional needs to take an increased risk cover. So what is it like for the insurance company? If you take only you take an insurance cover of 1 crore, and then suppose it is 100%. In a frivolous case, the insurance company can settle your case out of court and be done with 10 lakhs. So you would lose the cover for the rest of the year. So you need to be careful as to how much AOI and AOY you need. So what we need to do, we need to enhance your indemnity cover adequately, suggest that we take indemnity cover at AOA 25% so that at least we are covered for 4 accidents in a year. That covers for at least 4 accidents in a year. Always keep your indemnity policy, this is the most important, up to date, and pay your premium before the due date to avoid being lapsed, as there is no grace period for premium payments for indemnity insurance. Like for your life insurance, endowment insurance, life covers, you have a grace period of 1 month to pay your insurance. But for indemnity insurance, you have to pay your premium before the due date, or else the policy lapses. And how does it impact you? Like, always remember that there has to be an uninterrupted cover from the date of accident till the filing of the case. Suppose there is a cause of incident has taken place 1.5 years ago. The patient goes to the CPA. Now, while renewing your premium last year, you have a gap of more than a week or 10 days to pay your premium after the due date. That means your retrospective date will be from that date, and it will not be in a continuous mode from the date of injury for the patient. That means you won't be covered under indemnity, you won't be covered, you will not get that insurance cover. So you need to be careful about 2 things. Number 1, what is your AOY, that is yearly limit, and what is your AOA, limit per accident, and then you have to maintain your premium payment well on time before the due date. And so just in case you are not covered or have exhausted the indemnity, how is CPA 2019 going to impact you? The enhanced pecuniary benefits are going to kill. It is easy to file a case under CPA where there is no fee up to a bill of 5 lakhs. The patient can just go online and file a case. There is no fee for the patient to file the case. You are a professional. You please remove that. We have adequate time. I will be taking just 1 more minute. Yeah. It is easy to file a case under CPA where there is no fee up to a bill of up to 5 lakhs. Patients and advocates are tempted to meddle with this. You are a professional under heavy stress of high investment. You will be tempted to settle things by mediation, which can open the floodgates for future too. Oh, this doctor comes for mediation. Let us file more frivolous cases in future. In case you fight the case and lose, you are expected to deposit half of the compensation amount in the higher forum and appeal within 30 days if you are appealing from the district to the state commission or from the state commission to the national commission. But you get a time limit of 45 days if you are appealing in the Supreme Court. So take adequate precautions, care, and best to you all. Thank you for your patient hearing.
Thank you, Dr. Manoj, for this talk and detailing about the insurance details also, and be careful. You please be ready for your questions. You can submit your questions or you can ask yourself at the end of these 2 more talks are there. And now the next talk is from Dr. Pankaj Vashne. We invite him on the dais to speak on the value of consent in CPA court. We all take consents, and consent is valid or not valid. We should know about it, how to make it valid.
Good morning,
Over to
everybody.
Dr. Pankaj.
Supreme Court introduced Consumer Protection Act in medical services after the case of IMA versus VP Shanta and others on 13th November 1995, and new rules were added in 2021. We have to take precautions to avoid risk of litigations, and among this, consent is a part of documentation which is very important. Negligence is judged by the judges who are not trained in medical science, so they rely upon experts' opinion, reasonableness, and prudence. This has been explained by other speakers. What is consent? Consent is when two or more persons agree upon the same thing in the same sense. It should be voluntary, it should be free from coercion, fraud, undue influence, misrepresentation, and mistake. It is given by an adult. And who is an adult? He is above 18 years according to Indian Contracts Act and above 12 years as per IPC. Consent is a protection. It protects from civil and criminal liability, but it does not give total immunity if complication is due to negligence. It is a rescue to the doctors. It acts as evidence in courts. Denied consent should also be recorded. It should be recorded by the doctor, not by subordinate staff, in the same ink, and there should not be any cutting. There is no fixed format for consent. Usually doctors say that they don't have any time to write consent. If you don't have time now, then you spend your time and money in court. What are the types of consent? It is implied consent, which is from conduct, words, or the circumstances, also called tacit consent. Expressed when anything other than implied. It can be of two types, oral and written. Oral is for relatively minor examinations and treatments. Written is in simple language which patient can understand. There is no fixed format. It is also called explicit consent. Express written consent for all major diagnostic procedures, general anesthesia, surgical operations, intimate examinations, determining age, potency, and virginity, and all medico-legal cases. Usually patients allege that they did not understand the nature of medical procedure to which they gave consent, so the concept of informed consent has came into force. Informed consent is when doctor gives all relevant information of the disease and treatment to the patient in a language he can understand. It is about benefit of treatment, risks of the treatment, alternative treatments options, no treatment risk, and documentation with signatures of both patient, doctor, and witness. Consent should be procedure specific, not general consent. It should be in the same ink, no cutting, no overwriting, no abbreviations, exceptions being therapeutic privilege. Exceeding consent is a consent to a particular procedure. In exceptional cases, during operation, surgeon may cross limits to save life or organ of the patient. Proxy consent is from parents or close relatives of a child or mentally unsound or unconscious patient. Emergency consent is when in emergency there is no relative around, then a colleague must be consulted. Consent is not required in emergency, notifiable diseases, armed forces, new admissions to prisons, request by police. Now, who should be the witness to consent? Witness is the person who attests or testifies the fact and in front of judiciary. He should be ideally uninterested third party. He should attend the informed consent process, and he should be independent of the case, and he should not be unfairly influenced by the people involved in consent. Can be a nurse not directly involved in the case. Types of witnesses: signature witness to a particular signature, witness to consent process, he attests fact that information. Now, about witness, I would like to tell something very important. Usually in our practice, we take the signatures of relative of the patient as a witness, which is highly dangerous for us. Because when a case goes to court, and you say that you have already explained all the things to the patient, and patient denies it, then the court will ask the witness what happened. And if witness is relative of the patient, he will surely follow what the patient is saying. He will not favor you. So witness should be an independent party, not related to the patient and not related to the treatment. Now, few important cases about consents. In Shantaben Patel versus Breach Candy Hospital, National Commission states that doctors have to take risks with informed consent. Every operation has inherent risk and cannot be controlled, which cannot be controlled or avoided. In Shyamlal versus Dr. O.P. Nayak, National Commission said that endophthalmitis is a known complication of cataract surgery when done under informed consent, and a surgeon who does not have endophthalmitis is the one who does not operate. In Dr. S.K. Junjanwala versus Dhanvantri Kumar, Supreme Court says that in this case, patient said that he gave consent to lap chole, but open surgery was done. But consent included lap to open, so complaint could not be maintained. In Samira Kohli versus Prabha Manchanda case in 2008, there was no consent written. But in court, it was asked from the relatives, what were you doing when the surgery was being done? They said we were sitting outside. What did you do the day after surgery? They were at home. So the case was operated with consent, though it was not returned due to technical mistake, but there was consent, so case was dismissed. Thank you. This is our Delhi Ophthalmological Society annual conference, dates 7th to 9th October 2022. I am being the executive member of DOS, so I invite you all. Thank you all.
Thank you, Dr. Pankaj, for giving the importance of consent. And now I call upon Dr. Prakash Marathe, sir, to speak on the new CPA 2019 towards worsening doctor-patient relationship. We want to have the old relationship between the doctor and patient like trust, faith, and respect. We are losing it. How can we save? And where we should be cautious?
Good morning, all of you. I think this is the wonderful medico-legal symposium which has been planned by our chairman, Dr. A. Deshpande, who is not here. And basically the theme of this medico-legal symposium was new CPA 2019. And all these talks were around new CPA 2019. So you must be thinking why everyone is talking about that, because that was the theme. Another thing is that various aspects related to CPA 2019 are being discussed over here. Because this is the new CPA, there are few questions in doctors and general public's mind that what exactly is the difference. When government started this Consumer Protection Act, I think in the year 86, the city of Pune in Maharashtra, from where I am coming from, I am unfortunate to say that the people in Pune, they are important and they are responsible to bring this CPA for medical profession. That is the worst thing. In 1996, when it started, probably all doctors and medical fraternity thought we are under this bad domain. And in 2019, when this new version came, all medical fraternity felt that's very good. We are not under the purview of this CPA. But that was not correct. In my previous talk, I also said that unless it is written in the exclusion list of those professions of CPA, you are in CPA, you are under CPA. So don't be under that misinterpretation that it is not applicable for medical profession. It is not applicable for one profession, that is a lies. But then we are unfortunate for medical fraternity, lawyers are also responsible to bring us in domain of CPA 2019. So be careful what government thought, because the consumer's right should be protected. And because of this Consumer Protection Act, probably the society will be benefited, the consumers will be benefited, and medical fraternity is not getting benefited. What they thought, it is the better doctor-patient relationship will be there after this. But my topic is, this particular Consumer Protection Act 2019, it is towards worsening doctor-patient relationship. Before 86, it was different. When it was applicable in 96, again it was different. and 2019, it is a defensive practice. The patient with complications coming to you 10 years ago, probably you were taking the chance of suturing cornea, doing vitreoretinal surgery, handling accidental cases. What happens today? You are just trying to trying to send that patient to secondary center, tertiary center. You don't want to give that treatment to the patient because you do not have that safety. You do not have that cover of that particular law. It is getting against and against of our profession. What are the new things added? This slide is very important because so many things I'll be telling. But just remember, so medical fraternity, yes, no, that confusion is gone. Still it is under CPA 2019, medical profession. It can be out of, you can be out of that particular CPA if that particular list of exclusion, medical profession is added, yes, you will not be under that. But till today, we are under CPA. Next important thing is very important, compensation amount is increased. My previous speakers, even in my previous talk, and I will be telling, the compensation has been increased. That is the worst thing. From lakhs, it has gone to crores. But the good thing is, it is as per bills. Most of the ophthalmologist bill may be from thousands to lakhs, but most of the hospital bill, most of the times, doesn't go beyond 50 lakhs. So that is the good thing. It has to be proportional to your bill. That particular compensation is the good thing which can be for us. Worst thing is jurisdiction anywhere in India. What I said, the doctor is from Maharashtra, patient is from Assam. In the past, the complaint should have been in Maharashtra only. Now the complaint can be in Assam. Doctor has to go to that place and travel at and around wherever he is asked for. He has to go randomly, and that is a trouble for medical profession. And my previous speaker, Dr. Mathur sir, has said about consumer mediation cells. This is the new inclusion. Most of the times, out-of-court settlement is advisable in this particular law. And doctor, even if he is not at fault, hospital, even if it is not at fault, I think the mediation is promoted by court. Mediation is promoted by lawyers. And out-of-court settlement, some amount has to be given. But what about the reputation of that doctor? What about the reputation of that hospital? It is getting worsened. So this is important slide, but remaining things I'll be telling you. Doctor-patient relationship getting spoiled day by day. It is not improving. There was faith. There was confidence. Nowadays there is suspicion. Doctor is looking at the patient and the family with suspicion. The family is looking at the doctor with suspicion. So that particular faith is gone. Doctor-patient relationship has been spoiled. In the past, medical profession, doctors were talked about as professionals. Nowadays, the word they have changed because of this Consumer Protection Act, that is business and seller. The patient was client in the past, patient in the past. Now he's a buyer, he's a consumer. So the definition is changed in doctor-patient relationship. So they are thinking it is pro-patient. Government had thought when the act started, but it is anti-doctor. This is the worst thing. But patients are also receiving bad test of it. As I said, it is a defensive practice, what most of the hospitals and consultants and doctors, they have been practicing. For medical legal protection, suppose the patient who was coming to doctors and hospital 25 years ago, doctor was just trying to test any risk for that matter. But what happens today? You have to advise many more investigations like CT, MRI, because there has to be some proof, some documentation to defend you in the court of law. You are asking the patient to go for second opinion because that only can save you in the court of law. Suppose some different thing comes against you. And defensive practice, as I said, so faith was there, now it is suspicion, so both are affected. Doctors are answerable surely to few these things, like medical council, like it is state medical council, and MMC it was in the past, now it is National Medical Commission. Civil courts, you are answerable. Criminal courts, just now this topic is going on, that is consumer redressal, Janata Darbar, nowadays it is worst thing. All simultaneously or subsequently. You have to face test of all these things. So CPA is a special law of civil nature with the aim of social welfare to protect consumers with following features. No court fee. Now it is up to rupees 5,000. Simple procedure of filing, hearing, and deciding, etc. That's what they felt. Summary trial is there. Speedy redressal is there. Non-judicial members on forum. This is the worst thing. One of them should be a female. May not be knowing judiciary, but she is there. Not a court, but has a full force of it. That is quasi-judicial. Majority opinion is the order of the forum. Act is compensatory and not preventive or punitive. Applies to all paid goods and services, but only free services covered are medical. You are checking 99 patients as free, but one of them was paid, even in charity hospital. You are under this particular law. Then jurisdiction, we have talked about it. In the district forum, it was less than 20 lakhs. Now it is 1 crore. State commission in the past, it was 2200 lakhs. That was 1 crore. Now it is 10 crores. National, it was more than 100 lakhs. That was more than 10 crores now instead of 1 crore. So this particular revision is there. Then period of limitation, 2 years. For appeals, 30 days. Condonation is possible. So procedure, summary procedure, then complaint in 4 to 6 copies, affidavit, refer to opposite parties, then reply in 30 days, can be extended up to 15 days more. Hearing by president, plus at least only one member. In your absence, they can do this. Lawyer is not mandatory. Anybody can defend. Evidence on affidavit, expert, book references, if elaborate, may be asked to go to civil court. Order to be signed by president and one member. Ex parte decision is possible. This is very important. Some of the doctors or hospital, they have said that we didn't receive that particular notice, so we are not answerable. No, in your absence, they can give the result. They can give the opinion, and which may be against you. So appeal system is there. This particular, you know that, district forum, state commission, national commission, and then Supreme Court. So proposed changes, power of interim orders, power of injunctions, then increasing pecuniary jurisdictions, and the national commission only appellate jurisdiction. More benches of state, national commission. So I pray all of you should have very happy practice, not a case against anybody. Be careful. Documentation is the best thing possible. Records must be perfect, fantastic. And whatever you are doing, whatever is written is done. Whatever is not written is not done. So only documentation will save you in the court of law. So do the things, but at the same time, keep your records properly, take consents, inform consents, and have clear, steady, and good practice. Thank you. Thank you so much.
Thank you, Dr. Marathe, for a very elaborate talk. And now we are ready for question answer or panel discussion, your suggestions, questions. And I'll request if anybody is having a first-hand experience in which he is under some legal action. So what are the troubles he is facing, where somebody can help, AIOS can help, or panel can help, if you want to share your experience of any case. Because we all are under risk to have these kind of problems happen. I will start with mine. I did LASIK to one patient. Patient was very happy, 6'6". His father came to me, you have invested 2 crore rupees in the machines and I want to earn through you at least 1 crore rupees. And he filed a case against me. The case lasted 4 years. Despite having 7 evidences of other doctors having 6'6" vision written in the complaint itself. But still the case was not finished till 4 years. So what I mean to say, and it was enough emphasized, that never ever speak any loose word to any patient treated, operated by anybody else. Nowadays it is a common feature, patient come and says, I have come for second opinion because I am not happy with the first doctor. I will say particularly for the newcomers, though it is applying to all, many times what we feel that he is not happy with that person, so we should speak something so he will stay with us. He is trying to lure you, and it is the biggest mistake we are doing. So I will say, please be very open, firm, And even if you are wrong, means patient is saying that I am not treated well, say that you have been treated well. And what I have learned from my senior is I will speak, discuss, and treat as of today. What happened in the past, I am not going to discuss with you. Because what happens, he says, sir, मेरे को 2 महीने पहले ये हुआ था, उसने ये करा था. I was treated like that. You don't listen to it. My request is that don't listen. You say, do you have any complaint today? Do you have any problem today? I will start treatment from today. This will curtail 50% plus cases. Curtail. And otherwise, we all will fall in the same trap. I am saying this with my experience and my advice also. And now it is open for house. So,
I think Dr. Agrawal said one more addition in that. Suppose the patient comes to you with the complaint of the previous doctor. What you can say that at that point of time, that doctor must have felt about your case, about that diagnosis and that treatment. That may be correct on that particular day. Today I am examining you so that what he has said, that no loose comment against your colleagues. That's very important. Most of the medical legal cases are because of this issue only.
this is again, I will say the other way, what we feel when we are doctors. It is good about our profession that we want to be with the truth, but be practical. Wrong power, wrong site, wrong eye, sometimes wrong diagnosis, sometimes wrong medication. You write cyclomune, he can be given cyclopentolate. And there comes that your writing was not legible. So you are under negligency. But what I am saying, try to cover it up, all the mistakes, as if you have done it. If you feel that he has been done by him, or he is my opponent, he is against my practice, he is just rising faster than me, these things should not be there when you treat patient. That is my request.
And specific to your thing, what about IOL power? At the outset, we can try to convince the patient that any machine, there is a error chance up to 1.5 diopters. If suppose if you are getting a refraction surprise of say over 3 diopters, 4 diopters, then that's a different issue. But if it is minor, you try to cover up and not to speak ill about the other doctor as much as possible.
I think wrong IOL is acceptable, but few things which was told in previous talk, that is wrong eye, wrong leg, these things are not pardonable.
You should take utmost care to avoid it. You wanted to speak, sir.
Something about AOA and AOY. Just can you elaborate a little bit?
Yeah.
All of us, I think, have indemnity insurance of
Yes.
2 lakhs or so. Can you just specify?
Yeah, every insurance cover, indemnity insurance cover that you take are based on are guided by 2 basic facts. Number 1 is AOY, that is any 1 year limit. Then the second thing is AOA, that is any one accident, right? Suppose if you have taken, as I said, an insurance policy of 1 crore and you say that it is 100%. 100% means 1 accident per annum. Suppose if that get resolved with 10 lakhs, you don't get cover for the rest of the year. Suppose if if you have taken a policy of 1 crore and you say AOA 25%, the premium differs for all these things. For AOA 100%, the premium will be less. For AOA 25%, the premium will be more. That is, you are covered for 4 accidents, up to 4 accidents in that year, but the limit for your cover will be not 1 crore, it will be 25 lakhs per accident. So based on your risk profile, based on your anticipation, how much insurance you need to take on AOY, that is any 1 year, you can take, say for example, 5 crores, AOA 25%, that means for each case you are covered up to 1.25 crores. That is the thing. Yeah. Yeah.
It is very dangerous also.
But in routine practice, we take a consent from the relative. The witness is normally the relative.
That is practically
Normally
possible
the
thing only.
relative, that is very dangerous for you.
So whom should we take?
Third party, relative of other patient.
But
There can be 2 witnesses. 2 witnesses.
No, he has to sign. In my practice, I take 4 signatures. 1 signature is mine, 1 signature is of the patient, 1 signature is of the relative, and 1 signature is of witness. And witness is relative of another patient because we are operating 3 or 4 cases. A case, B's signature, B's relative, for B's case, C's relative, for C's case, A's relative. So that is enough.
Lot of hospital nowadays use video recording of oral communication with the patient and relative.
Video recording and audio recordings are taken as evidence in court of law only if they are submitted and deposited as an evidence in any court by 5 p.m. of that day. Otherwise, yes. Otherwise, that audio or video recording is not taken as evidence as per Evidence Act.
And
No use.
Another thing is that it should be recorded, the same thing should be submitted. It is not like recorded somewhere else and you copy it and submit. So that also is the issue.
And where the SIM card or the hard drive where you have recorded, that has to be submitted as an evidence.
Not from the other device. EMR validity is there if they can prove it that it cannot be overwritten in backdate. Like EMRs, there's many people who say that our EMR person is very happy and healthy because he is cooperating with us and we are also happy. It is not like that. If your EMR can be easily changed for the backdates, it will not be taken as evidence. You understand? So many people feels that we have a local EMR guide and he will do the changes. So changes if can be done, it is not.
Are we right to refuse a patient whom we see in the OPD if we feel he's a tricky, we don't want to see him, examine him? Can we refuse that patient? And in surgery case also, suppose we feel we don't want to operate, can we refuse that?
Yes. In
yeah,
now
you can.
new ethics have come from National Medical Commission. In that there is special mention that such patients definitely can refuse.
Here there is a caveat. Here there is a caveat. Here there is a
Except in
caveat.
case of
If he
emergency.
says that I
Except
need
in
a
case of-
emergency care, then you
Except in
cannot
case of
refuse.
emergency.
If he says, so you have to prove that he actually didn't require emergency care, and indirectly you will require to prove why you have not seen him. So you can't differentiate by caste, you can't differentiate by gender, you can't differentiate by his economic status. So there are so many limitations that you cannot refuse patient seeing unless you prove that before he started seeing, he started making fight with me. He started alleging me. He was disrespecting me. And that you have to prove. So refusing a patient is not a good habit. No. Even if it is problematic, try to take actions or documentation where you can be saved later on, because you are seeing that this patient is going to create a trouble. So then you have to say, because of some emergency reasons, I have to go, or right now I am not feeling well to treat this patient or that patient, or whatever the expert panel suggest you, but try to be calm at that time. Try to be at calm rather than anger.
Regulations pertaining to the fee structure, like how much one is charging in the OPD.
No, right now
There is
no.
no rule.
Right
There is
now
no
no.
rule.
Right
There is
now,
no rule.
That madam wants to ask something.
No, in fact, in one of the judgment, court has said it is your right. Government is trying to fix your fees in that judgment. In one, I think in Bombay court only, they have come out that it is the right of a doctor to charge his own fees. But sooner we will be limited.
But one
Fees of
caveat-
advocates cannot be finalized. Fees of professionals, architect, anybody's fees cannot be freeze. So you can't freeze medical doctors' fees. So that is the right. It cannot be violated.
But
in
one
Clinical
caveat here is-
Establishment Act, in Clinical Establishment Act, they are trying to do that, but we are fighting against it. Yes, madam. You have
Yeah, that's
yes,
exactly
yes.
what I was trying to say. Dr. Nirmal in his presentation said your fee structure has to be transparent, whether it is for OP or IP cases. Yeah, it should be like you can't say I charge 500 rupees to everyone and charge 1,000 rupees for the other patient without any suitable justification.
We need to always give in writing like the diagnosis, or suppose like some disputed patient comes in, is it okay if we just give the prescription, or all the diagnosis, the findings, everything needs to be given?
You,
diagnosis
you
can
need
be
to give a
provisional
case-
one, differential diagnosis. Sorry. Yes, continue.
Okay, it's a good practice to give a case summary. So, with salient history, your examination points, diagnosis, and your plan of care. So that includes the investigation and the first line of management. So it's a good practice, and also standards emphasize that we have to give a report.
Try to be careful here. If anybody is asking you this way, he wants to go against you, means or he will go because he is not happy or satisfied. So write the advised investigation, at least that these are the investigations advised for confirmation of diagnosis. He rightly mentioned make it a provisional diagnosis. But why it was provisional? Because I wanted these tests. So that is very important.
Better is write down the diagnosis as differential diagnosis and put a question mark after
Yeah.
that, so that it is under consideration. And one thing more I would like to say, whenever you receive a notice from opposite party or patient, there will be number of points which you have to reply. Now remember one basic law, that it is the complainant who has to prove his case, except in case of rape, adulteration and fake currency. So do not reply until and unless the patient proves negligence against you.
So you want to say that if we receive a notice,
Yes.
we didn't
So
know to
suppose
reply.
he has said point number 1.
Yeah.
Answer is, I don't accept my mistake. Please prove the case with evidence.
Good.
Point number 2, second query, I don't accept. Please prove the case with evidence. Third query, I don't accept. Please prove the case with evidence. You have to give reply.
Yeah,
But in
that's why-
every reply, you write down that I don't accept your allegation,
Accept or
and
deny.
you have to prove it with evidence. Only after that I will give proper reply.
So the
So
take home
reply
that
is mandatory.
You need to reply.
So whenever you get a notice, please reply. But refute all allegation, as Dr. Pankaj said, they have to prove that in the court of law with proper evidences.
And this is the time when you look back
And you
your
are
records.
within your right to ask for all these evidences, a
With-
copy of all those evidences which the patient has
he will not be
submitted.
able to prove negligence against you because he doesn't have any evidence.
So, but improve your records at this time at least. And take those records under custody of yourself. Don't leave it in this medical record section. Anybody can copy and give to the patient, and which is not complete, and then you change something. Ideally, it is not allowed to change. But what I am saying, make your records complete. Take legal opinion at that time whenever you receive the first letter. If you delay it, that this is the first letter, I replied, I not accept. And within no time, you will not find and forget many things. In recent case, you remember every situation and try to note down the situations of the other talks happened at that time for your notes. Prepare one extra notebook in which you can write what actually happened on that day with that particular patient, what was the reasons, and try to remember who are the persons with him at that particular time. The relative, his brother, sister, wife, or whatever, who came, his friend came, what are the other people, who has referred that case to you, you discuss with him, how much he knows about it. Because these things 2-3 years later will forget. So try to make one special note for this kind of case.
In a consent for surgery, does the witness have to sign in presence of the patient?
Yes, everybody has to sign
Bombay
together.
High Court has given
and
a one
time
decision.
should be the same. I have seen at various hospitals signatures of patient at 8:10 a.m. signature of the doctor at 9 a.m. That is, consent is not valid.
Bombay High Court has given one judgment which is funny, but they have given the consent should be signed by same pen. Even if the pen is different, consent
Yes,
is
even
invalid.
if the pen is different, it is not acceptable.
So
Should be in the
Corona
same ink.
also it
Should
was
be in
not
the
a
same
defense.
ink.
So, but my humble submission and suggestion, whenever any case happens on any of one of us, we should discuss it in detail in public. We get shy. If I discuss this case, he will say, oh, Virendra Gwal pe case ho raha. Who will say what? He will say what. We should discuss with each of our colleagues, friends, inform them. And that is how we will become learned, we will become careful. At the same time, it will create a public pressure on the other agencies that they will understand ki what they are doing wrong, which is discussed by the public.
About the consent, one important feedback. About the consent, one important feedback. Sometimes it is said that the consent was taken too early. Another thing is consent was taken too late. Suppose you are operating today at 9 o'clock and consent is taken at 8 o'clock. Probably the patient may say, everything was not explained to me. So there is one alternative which we have tried at our IMA level, that when the patient is coming for fixing the surgery, you can give that consent to the patient, ask him to sign and bring it back, and again on the day of surgery you can have another set. So that early consent is also there, late consent is also there, and in between patient was given some time to think about the procedure, its consequences.
Consent means signature.
No.
Uneducated patient.
Thumb.
Yes, yes.
Thumb and then witness.
Left thumb impression, and the person who is taking thumb impression, he has to sign. Circle it and sign it. Anybody who is taking the thumb impression.
I think this is a very good question and situation.
Yes. Any staff of the hospital who is taking thumb impression, he has to write down a left thumb impression or right thumb impression and should sign it with date and time. Yes, but
This is a very good question. I will add on one precaution. The
Then-
person who is illiterate will claim, I was spoken and given different version what is written over here. So whosoever is signing as a witness for it, he says, I understood and I explained. And after explanation, I took his consent. And that consent I am signing as a witness.
One more thing about the thumb. There was one
patient's
case.
relative will sign because for his patient, someone else has to sign. If he doesn't sign, other one will also not sign. And his surgery will not be done.
About the thumb, just remember that the patient is educated and you are taking the thumb. This has happened. The patient was dead. The signature was not taken on the consent. And afterwards the thumb was taken. So when the patient is educated, how will you give the thumb that? And he was not signed. So that's what you have to remember.
And in that, the language is also an issue. A person signs in Hindi and consent is in English, it will become invalid.
Yes, in the same
At
language.
AIOS level, we have come up with informed consent booklet. We have translated that in Maharashtra in Marathi version of that particular booklet. Even in Hindi, they have tried. And local language version is available which each state, now they have been working on it.
The yes. Excellent. Yes. It is a
Consent
part of the
already.
consent.
It was read before me, it was explained to me, I understood it, it was told to me in my local language, everything.
Just, can I make a comment on this? In one court of law, it was rejected because this was written in English. Okay, this has been explained to me in my local language, it was written in English. So the judge said, how can he understand what is
No.
There is a role of witness. There is a role of witness in that case.
There the role
that-
of witness comes.
Yeah, there is a role of
There is
witness.
the role of witness comes.
And another thing, as you said, the consent should be for that procedure, for additional procedure, together. It should be there together. Now the things are happening that if you are planning vitreoretinal surgery, then you have to do a silicone oil removal later on. That should be the part of the consent. The another thing, as I said in before also, now we are just 40 people here. And we have to reach to 25,000. The only way is to discuss your case to each and everyone you know. Then they will understand.
Okay, with that, the time is up, sir. Sorry, we can discuss outside. They are pointing the time. Yeah. So,
We request for a group photo
thank
of
you
each
all
and
for
everyone who are
attending
here.
this session.